Alex here with the video on the Fair Debt and Collections Practices Act, the F.D.C.P.A. for short. I have been getting questions on the F.D.C.P.A. from people who are being hounded by creditors and they want to know how to fight back. I, okay, so the primary way for anyone out there to harness the power of the F.D.C.P.A. is, sadly, to read the F.D.C.P.A. and it is boring. And it is, well, it's not as long as some of the stuff. It's quite a read. There's a lot to it, but it's not as bad as it could be. It's you can get through it probably in like a week if you spend a few hours on it a day. But there are some tidbits of information that I can give you in the video. Some things that I can remember from my time working as a collection agent, working at a collection agency. I didn't do those annoying calls, just if you guys are wondering. I didn't call people and try and collect monies. I did the legal end. In fact, for the most part, people called me when their wages got garnished and their bank account got levied. The debtor would usually call me, not the other way around, and try and figure out how to stop it. But I did all that stuff. In fact, my experience doing that is what led to the video Execution and Asset Seizure, because I learned how to execute and seize assets. Anyway, the F.D.C.P.A. was always the monster, like the demon, the boogeyman under the bed. When you work in collections, you don't want to get sued under the F.D.C.P.A. because it hurts, it's expensive. Each infraction is a $1,000 fine, and then you may have to pay compensatory damages and all that other stuff too on top of that. So we learned how it worked, and we tried to comply with it. One of the companies I worked at was a lot better. The other company really went up to the line and tried to get away with as much as they could. Whereas the company that I mentioned before that was like really big on giving people, extra time and more cushions, and they just wanted to be as nice as they possibly could to the debtor. They didn't want to get anywhere near an F.D.C.P.A. violation. It was a big deal to that company. So anyway, there are only a few things that I can remember off the top of my head that really jump out at me, guys. Only a few things, and I wish this could be like a 20-minute, 30-minute video with tons of details on the F.D.C.P.A., but I feel like I got the point across in the beginning for everyone here to read for themselves what the F.D.C.P.A. was so they could learn how it worked. First thing, it's federal. Yes, you can sue in federal court, but you can also sue in state court, and I heard of usually those federal statutes being brought up typically in like a counterclaim. So like a debt collector, a collection agency will sue, and somebody will hire a lawyer, and then they'll try and defend the lawsuit on the debt. They'll try and defend the debt, and then they'll also throw in there some F.D.C.P.A. violations as a counterclaim, and they'll try and get the money that way. I've seen that happen before, and it can work. I don't see why not. I don't remember anything jumping out at me. I don't know why you can do that sometimes and not other times with federal law. In fact, I know there's a term for this. There's a term, a legal term that I can't remember the name of right now, that sort of encompasses the ability of a person to use federal, or maybe it's the other way around. It's one way or the other where you can use either federal law in state court or state court in federal law. And the way that you can go about doing that is not just however you feel like it. There's a doctrine that controls how and when that can occur. Anyway, take a look into that if you'd like to. And if you find the term, put it down in the comments below for some bonus points. The other thing that I wanted to mention is not every debt collector is covered under the F.D.C.P.A. Some, especially if, first of all, if the company that's owed the debt goes after you, they're not under the F.D.C.P.A. They're just not. The F.D.C.P.A. covers collection agencies, these third-party companies that buy debts or take assignments of debts and try and collect them for somebody else. When it's the actual creditor themselves, like they didn't send it to a collection agency, they're just going after you on their own, they don't even have to worry about the F.D.C.P.A. Same thing, for the average person. If you're going after, your buddy Tom from work and you sue them, they can't use the F.D.C.P.A. against you. You didn't send that to a collection agency. You just went after them on your own. That's the first thing, is find out if the F.D.C.P.A. even applies, because it might not. The next thing is there are certain things that they can't do. For example, in the old days, debt collectors used to harass their debtors by trying to embarrass them or shame them. So embarrassing and shaming them would involve like telling their neighborhood about them, telling their family about them, telling their boss, like their coworkers, and they can't do that. They have to figure out where you are and they have to talk to you directly. The only exception is if you give them permission. I think it has to be in writing. If you give them permission in writing, they can talk to somebody else. They might be able to talk to your spouse. I'm not sure that that's a problem. If you're married, that should be allowed. But I'm not 100% sure on that. So if your collection agency is talking to your coworkers, your brother, your sister, your mom, your neighbors, your boss, that kind of stuff, that's a violation of the F.D.C.P.A. And I'm going to get to the end of the video. I'm going to talk a little bit more about why that's a problem. So anyway, they can't do that. The next thing they can't do is they can't like intimidate you. They can't threaten to beat you up. They can't threaten to vandalize your property or your car. I'm not sure they're even allowed to go to your house anymore. I heard about this. I heard about debt collectors in the old day physically going to your house and knocking on your door. And I guess that's like a form of intimidation because it's sort of letting you know, hey, I know where you live. I'm not sure that they can do that anymore. I'm not 100% sure on it because, I mean, if they find you specifically, they might be able to say that they're just contacting you in person instead of through all these other means. But anyway, even if I'm wrong and they can go to your home or your job, there's still a way to stop any of that anyway, and that is when you send them something in writing saying to stop talking to you. Believe it or not, if you tell them to stop talking to you, they have to stop. You can't tell them over the phone. That's not good enough. You have to send them something in writing. But once you do that, if they try and talk to you anymore, that's a violation. This is something that shocks people. A lot of people think, whoa, if you owe money, shouldn't they be allowed to kind of bug you all the time because you owe money, right? No, that's not true. The purpose of trying to collect money is to actually collect the money, not to harass and annoy someone. So if you call them and they tell you stop talking to me, then your remedy is to go to court. That's the way that the federal government feels. If somebody says stop talking to him about the debt, then stop talking to him. Sue him. If you don't want to sue him, then you're done. Just, that's it. Stop talking to him. That's one of the things, that's one of the ways you can get some of these careless collection agencies nailed with F.D.C.P.A. violations, is to say, hey, stop talking to me. I'm sending you this letter. Cease and desist. And they'll, if they keep, sending you mail or calling on the phone, each one of those is an F.D.C.P.A. violation. If they don't like it, they can sue you, but they can't continue to annoy you. The next thing I wanted to mention is uncollectible debts. So they can't tell you they're going to sue you when the debt itself is not collectible. This happens typically when the debt is out of statutes, or I guess there could be other reasons as to why the debt's impossible to collect on, but mainly that's the main reason. The statute of limitations has triggered and they cannot collect. If that happens and they threaten to sue you, they are committing an F.D.C.P.A. violation because they're not going to sue you. It's impossible to win. They're lying. If they say that they're going to sue you, they need to be legit, willing, and able to sue you. That is something that's come up in court before, and they can't use that as a threat unless it's actually something that they can and will do. The next thing is uncollectible debts can only be collected voluntarily. So they have to, well, they don't have to, but typically to be safe, because they don't want to get sued, usually they will say, hey guys, we can't sue you to collect this debt. And they'll say it really quickly, like one of those commercials on TV. They'll be like, we can't collect this debt, so you have to pay voluntarily, we won't sue you, and then all of a sudden they'll say, so opening up your account, they'll speak really slowly at that point, and they'll hope that you didn't hear any of the other stuff they said because they went really, really fast. And anyway, if you listen carefully, you would have heard that they said something like, your debt's not suable, it's out of statutes, we can't sue you, you have to pay voluntarily. And now that they're speaking really slowly, they want to distract you with all this other stuff and bring up the debt and all that. They're hoping that you won't be paying attention and that you'll pay a debt that's uncollectible. Guys, forget all the morals. These corporations and these debt collection agencies, they don't pay uncollectible debts. So why should we? They're going to try and play the, you should be a good person and what's wrong with you? Why don't you pay your debts? Don't you feel like blah, 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 blah. You know what? If the tables were turned and they were hit with uncollectible debts, do you think they would pay? No, they don't care. There's no morals behind it at all. Once it's expired debt, that's it. It's over. It's done. Don't pay it, guys. Just don't. You have other things that you could be buying. Other things that could make you happy, that you can provide for your kids, all that stuff. It's just the way that the law works, and that's exactly what they would do too. That's exactly how, if they owed you money and it went out of statutes, they wouldn't pay you. They could care less. There's no morals. There's no ethics to these companies. They just won't pay. So anyway, I can think of maybe another one or two things with regards to the F.D.C.P.A. The validation. Okay, so there's a rule on validation. You when you get that first letter, you have a right to request validation of the debt, and it's I think you have to do it within like 30 days. And if you don't do it, most of the companies will still validate the debt anyway because they think about, hey, maybe if we validate it, he'll actually pay. We're not going to just not tell you what you owe and then be surprised that you're not paying. So, I mean, for the people out there who don't do this within 30 days, you'll usually still get some kind of validation anyway. But once you request the debt be validated, they cannot contact you anymore until they send you validation. So they'll send you something in the mail at some point in time. And once they send that, then they can contact you again. And in fact, you know what? I don't even think they can sue you. I think once you say, hey, I want validation, like you put the brakes on everything. It's just done. I guess I should mention this. Not all debts are bought. Some people think that they just buy debts like for pennies on the dollar and then they try and collect. It's not true. Sometimes they'll get like an assignment to collect the debt. And in fact, both of the collection agencies I worked at, that's how they operated. And once they collect the debt, then they distribute a percentage of it back to the actual client who gave them the debt to collect, and then they keep the other percentage. So it's a different business model. So they're not all debt refactors. They're not all buying debt. I guess one more tip I want to give you is you're most likely to be sued if the debt collector is in your state. If the debt collector is one of those gigantic national companies, they're probably not going to sue you. And if they are, they're going to like assign it to some other debt collection agency really close to you. The debt collection agency that you have to worry about usually is the one that's like around the corner, the local one. Those are the ones that have access to the local courts where you live, and those are the ones that'll usually sue you. So once you get sued, this is another thing that they do. They won't always sue you in small claims, guys. When I worked at my collection agencies, they didn't. There were people who owed $500 and they got sued in justice court, civil action. They got hit with attorney fees. I'm not even joking. There were people who had to pay $200, $300 in debt and then like $500 in attorney fees. It's completely legal. And the reason they do it is because they want to get paid for the work. If they sue you in small claims, they can't collect attorney fees. Not in Nevada. It's not allowed. If they sue you in justice court as civil action, well, okay, small claims actions are still in justice court. It's a different action. Anyway, if they sue you under civil action, then they can collect attorney fees, and they will. And the other thing that's frustrating for people is that it doesn't go to a hearing automatically. I can't tell you how many people had no idea. They thought that, this is going to go to a hearing, and then I'm going to go into court, and I'm going to explain everything. Nope. They didn't file an answer. So since they didn't file an answer, boom, default judgment. Next thing you know, writ of garnishment. By the time these guys figure out what's going on, they've already been garnished. Their case is closed. They've lost. They don't even know what happened to them. So pay attention when you get served with a lawsuit. Pay attention. Don't just assume you're going to get a hearing. You don't always get a hearing. The collection agencies that I worked at, most of the lawsuits were civil actions in the justice court, and like 95% of the defendants didn't even file an answer. And so once you don't file an answer, no hearing is set. The court just assumes that you agree to everything, that you admit everything. And so they'll enter default, they'll go straight into execution, and they'll start taking your stuff. Not even playing around. That is something that most of the time happens. For the person that does file an answer, you better win, because if you don't win, the attorney fees are going to be higher. It's just the nature of the beast. Once it goes into litigation, now the attorneys are going to attorney fees are going to be much higher. And the other thing that I was going to mention is, I don't know if this is a strategy that attorneys would give you, but in my experience, if there's something that you own up to, just own up to it as quickly as you can, because then you can use that as a defense against attorney fees. So if you have a landlord who's trying to charge you all this money, but you really only feel that you owe like $200, tell them in the answer, hey, I admit to all this other stuff, but I don't admit to this one thing. And that way, when it goes to court, they can't collect attorney fees on all that other stuff because you admitted it. You can tell the judge, Your Honor, I object. Why are you giving them $2,000 in attorney fees for proving 18 different things when I admitted 16 of those in the answer? The only ones that I didn't admit to are these two. So if they're going to get attorney fees, they should get attorney fees only on proving those two. You don't need to come into court and prove things that I admit to. Anyway, that's just some logic for dealing with collection agencies. I guess the last thing I wanted to mention is bargaining. It's not that easy to bargain with a collection agency that's local and has access to a local court. Believe me, a lot of people that I dealt with thought that they deserved a deal. They wanted discounts, 50%, 75%, 80%. That could work with a debt refactor, but that won't work with an assignment, a company that takes assignments. It's different. It's a different business model. They're not looking to just get cash. It depends on how much of a target you are. If you have assets that are easy to seize, they won't cut deals. And that happened all the time. If you're a person who's struggling, if you're working at Taco Bell or Walmart or you're in college and you just don't have much money to your name, then you're probably going to get a deal. If you're not going to get a deal, you'll at least get a really good payment plan. That's another thing. You guys just can't get payment plans just because you want one. People thought that, hey, I'm going to do this payment plan, and if you don't like it, too bad. And then I would just say, okay, well, now you're sued. You know what the payment plan is? 25% of your wages every check. And it's not that you want to be mean to them. It's just that they're making money hand over fist, and they're very good targets because they're making so much money, and they want to pay like $50 a month. That's not how it works. If you're making $6,000 a month, you're going to have to pay a lot more than just $50 a month. And it's just the people who really played the most games were the wealthier people. The people who were really poor had all the latitude in the world. They would pay sometimes $10 a month. I'm not even playing around. And the reason why is because it was so difficult to collect from them. The law gives them protections. The law doesn't protect the people who are making more money that much. They protect themselves sometimes, by hiring really good lawyers. But when you're talking about seizing their assets, they don't have very many protections. You can seize most of their stuff, and so they should keep in mind that you're not entitled to a payment plan, and that the collection agency is going to be looking at a payment plan that's going to be very close to what they would be able to seize anyway. So if they would be able to seize $2,000 a month out of your check, they might be like, okay, we'll do a payment plan for $1,200. It's nice to have some voluntary, cooperation on this, but at the same time, it's not going to be $300. It's just not, because we can seize $2,000. What are we going to do? Take a payment plan for $200 or take $2,000 out of your check? Obviously, they're going to go with plan B. It's more money and it's quicker. So just a few things. I hope that this is useful for people. Oh, the last thing that I wanted to mention towards the end of the video is why. Why does the F.D.C.P.A. protect people who owe money? The reason why is because not everyone actually owes money. Some people legitimately have a defense to these debts. And so what was happening in the old days was people were paying the debts because they were being embarrassed. The collection agencies were collecting on debts that were not really debts. They were lies. They were fake. That was money that wasn't really owed. If it went to court, the defendant would win. But the collection agency didn't care. They wouldn't care about right and wrong and what the truth is. All they would care about is, if we smear this guy's name through the mud, he's going to get embarrassed and he's going to pay us. Not because it was truly a debt that he owed, but because we twisted his arm. So that's why there's all those rules there. If the company if you actually owe the company money, then they need to try and get the money legally. They need to go to court or get you to voluntarily pay. They can't be pulling all these games, these nasty, sneaky, honestly, it's despicable tactics to get people to pay money that they don't actually owe. It's like, seriously, if this is money that I owe, take me to court, prove it, because I'll defend myself. That's the way that a lot of the people would, sort of want to approach that problem. And then the collection agency started calling their boss and their sister, or showing up at their house and saying, hey, I know where you live. And people would pay just because they were scared. That's so wrong. People should pay debts that are valid. People shouldn't pay because they're afraid of the manipulative, conniving tactics of a collection agency. I didn't mention this. They also can't call you all the time, like in wee hours of the night, early in the morning, like 16 times a day. They can't do any of that stuff either. I just kind of glazed over that stuff. Anyway, learn about the F.D.C.P.A. It's out there. It's powerful. It works. It's both of the companies that I worked at got stung by it multiple times. So anyway, I'm going to go ahead and get off now. If you guys have any questions, feel free to post it down in the comments below, and I'll see you guys around.